Welcome to the Deep Dive. Today, we're tackling a really foundational area of law, equity and trusts.
Absolutely. It's a big one.
And we're using materials provided by the University of London. It's important to say right at the start, this is purely for educational purposes.
Exactly. We're just exploring these resources to help understand the subject better.
Our goal today really is to give you a clear picture of how this module is put together and maybe offer some, smart ways to study it successfully.
Yeah, because this isn't just any module. It's one of the 7 foundations of legal knowledge. Super important if you're aiming to be a barrister in England and Wales.
So we're going to break down these University of London resources, hopefully give you a good feel for what's involved.
And how best to approach it.
So that's the mission, a practical roadmap for the Equity and Trusts module using these great materials from the University of London.
And we should definitely thank the university for making these available to students. It's a fantastic resource.
Absolutely. So for anyone maybe new to this, what exactly is equity and trusts law? Let's kick things off there.
Okay, yeah. So historically, you had the common law courts, right? But sometimes the strict rules led to, well, unfair outcomes.
A bit rigid sometimes.
Exactly. So the courts of equity developed alongside them, offering a more flexible, fairness-based approach.
And the trust concept came out of that.
Pretty much, it became this incredibly useful tool within equity. Basically, a trust is just a way of holding property,
Where one person, the trustee,
holds it and manages it for someone else's benefit, the beneficiary. It's fundamental for managing assets, family wealth, charities, all sorts.
and it's interesting how that historical idea of fairness still runs through the modern law.
It really does. The University of London's materials really stress understanding these core principles, both equity and trusts, and also getting to grips with the controversies and the difficult bits.
It's not just memorizing rules then.
Not at all. It's about the why, the principles of fairness and obligation underneath.
Okay, so the module seems to focus on 3 main areas, broadly speaking.
That's a good way to put it.
First, how do you actually set up a valid trust? What are the ingredients?
Right, looking at the different kinds of express ones you create on purpose, charitable ones for public good.
And then those ones that sort of arise automatically, like resulting in constructive trusts.
Exactly. Second big area, what are the duties and responsibilities of the trustees? The people actually managing the assets. Fiduciaries.
Right. What standards do they have to meet?
And third, what if they mess up? What happens when things go wrong? What can the beneficiaries do? The remedies.
Creating the trust, running the trust, fixing the trust when it breaks.
In a nutshell, yes. And it's worth mentioning who convenes this module.
Ah, yes.
It's Martin Dixon. He's professor of the law of real property and dean at Queen's College, Cambridge. Also an honorary bencher of Lincoln's Inn.
So definitely someone who knows their stuff. His expertise shapes these materials, presumably.
You'd expect so, yes. They're very comprehensive.
Okay, let's shift focus slightly. What are you actually expected to know by the end of this? The learning outcomes, the knowledge side.
Well, first off, it's crucial to understand the modern law, but within its historical context.
Oh, why did equity pop up in the first place?
Exactly. And how does that history still shape things today? It's about appreciating the why, not just the what, the equitable foundations.
Got it. Like understanding the building's foundations. What else?
Then being able to compare and contrast the different types of trusts. We mentioned express, charitable, resulting, constructive.
What makes a family trust different from a charity, fundamentally?
Yes, understanding those distinctions, their purposes, how they work differently, that's really important.
And applying the law itself, statutes.
Absolutely key.
Yeah.
You need to be able to spot the relevant bits of legislation and actually apply them. Trust law isn't just old cases. Statutes play a big role.
Practical application.
Definitely. Then there's the whole area of breach of trust.
When things go wrong.
Right. You need to understand how a trustee can breach their duties, but also, crucially, what happens next. What are the consequences?
Remedies available to the beneficiary. This is where the rubber meets the road, really.
It is. Protecting the beneficiary's interests. And finally, the module pushes you towards critical thinking.
Not just accepting things at face value.
No. Evaluating how judges reach decisions. Thinking about the ethical side, the societal impact of trust law.
And engaging with what academics are saying. The debates.
Precisely. Understanding different interpretations, critiques. Developing your own informed view. It's not just about rote learning.
It really sounds like these areas all link together, doesn't it?
They absolutely do.
You can't really understand remedies for breach without knowing how the trust was set up and what the trustee was supposed to do.
Exactly. It all connects back to that history and the statutes, too. It's a whole picture.
So that's the knowledge base.
Hmm.
But the module also aims to develop specific skills, right? Practical abilities.
Yes, definitely. First up is applying that
To
knowledge.
solve problems.
Complex ones, yeah. Both practical scenarios like advising a client and more theoretical legal arguments, using what you know in new situations.
Not just reciting facts.
No. Then there's synthesizing arguments, being able to pull out the key points from, say, long judgments or academic articles.
Understanding the reasoning. A core legal skill.
Absolutely. And building on that, honing your analysis.
How so?
Being able to tell different legal arguments apart, see their strengths, their weaknesses, really picking them apart critically.
The heart of legal reasoning.
It is. And finally, using the language correctly.
The jargon.
Well, the specific legal terminology, yeah. Words like fiduciary, equitable estoppel, they have precise meanings. You need to use them accurately.
So pay attention to the vocabulary list, basically.
Definitely worth to.
Okay, so we know what we need to learn and how we should be thinking. Let's get into the nuts and bolts, the actual topics covered in the module structure as laid out by the University of London.
Right. It starts, logically enough, with the basics, defining what a trust actually is.
Setting it apart from other legal ideas.
Yes, getting that foundational understanding right first. Then it moves into classifying trusts broadly and the general principles of equitable rights and remedies.
Laying the groundwork.
Exactly. Then it dives into express private trusts, the ones deliberately created.
Focusing on the three certainties.
That's right. Certainty of intentions, subject matter, and objects, the beneficiaries. You absolutely need those, plus any statutory rules, the formalities.
And what about trusts that aren't quite fully set up?
Yeah.
Or secret trusts?
Yep, it covers those two incompletely constituted trusts and the slightly mysterious world of secret trusts.
Intriguing. Okay, where next?
Logically, it moves on to the trustees themselves, their powers, their duties. What can they do? What must they do? Including delegation, when can they pass tasks to others?
Makes sense. And charitable trusts.
They get significant attention. How are they defined? What counts as a charitable purpose? How are they different from private trusts, especially that public benefit requirement?
And that CPRE thing you mentioned.
Yes, the C-Press doctrine, that's about changing a charity's purpose if the original one becomes impossible or, impractical.
Right. What about the trusts that just sort of happen?
Resulting trusts, they arise by law in certain cases, like if you chip in for a house but the title's in someone else's name.
Or those quis-close trusts money for a specific purpose.
Exactly. And then constructive trusts, also imposed by law, often where there's been some kind of wrongdoing or unjust enrichment or a breach of fiduciary duty.
Oh, okay. So lots of different types. What else?
Practicalities. How do you appoint trustees? How do they retire? How can they be removed? The mechanics of it.
And then, inevitably, remedies again.
A big section, as you'd expect. What happens when a trustee breaches their duty? Things like the duty to account, equitable compensation.
Can they limit their liability with clauses?
Potentially, yes. Exemption clauses are covered, as are the rights trustees might have against each other, like indemnity or contribution.
Right. And does it stop with the trustee?
No, it also looks at liability for others involved, accessory liability. Things like dishonest assistance or knowing receipt where third parties get dragged in.
And following the money.
Tracing, a vital, if complex, area, following trust property that's been misapplied. And finally, it touches on how trusts relate to other concepts like lawsians and subrogation.
Wow. Okay.
Mm-hmm.
That is comprehensive.
It is. It covers a lot of ground, which might seem a bit daunting.
Yeah, just hearing the list.
Which is exactly why having good study strategies is so important. And the University of London materials give some really solid advice here.
Okay, let's talk reading strategy. Textbooks first.
Yes. They recommend choosing one of the two core texts, Penner's Law of Trusts or Virgo's Principles of Equity in Trusts.
Just one.
They're quite clear using both isn't needed, doesn't give you an edge. The key is finding which author's style works best for you.
How they explain things, how they structure it.
Exactly. Different people click with different styles, so maybe browse both if you can, see which one feels like a better fit.
Good tip. And how should you approach the reading itself? Order matters.
It seems so. They strongly advise reading the module content on the VLE and your chosen textbook chapter before you tackle the actual case law.
Get the framework first.
Precisely. Build that foundation, understand the principles, then read the judgments. The cases will make much more sense in context.
Rather than just diving into dense judgments cold.
Exactly. Trying to do that first is like trying to assemble flat pack furniture without looking at the instructions. You need the overview.
And the sample questions, when do they come in?
After the essential reading, get the knowledge down first, then test your understanding and application with the sample questions at the end of each topic.
Don't jump the gun on the practice questions.
Probably wise not to. They can feel tough if you haven't done the groundwork.
What about further reading?
That comes later, too. Once you've got a good handle on the course stuff, use the further reading to go deeper, explore nuances, different perspectives.
So core reading first, then cases, then practice questions, then further reading if needed.
That seems to be the recommended flow. And a really crucial point, the statute book.
Ah, yes, Blackstone's.
Blackstone's statutes on property law. You get access via an ebook. This is vital. You need it throughout your studies.
And in the exam itself.
Yes. So getting familiar with it, knowing where the relevant bits are, is absolutely essential.
Are there other books they mention?
A few, yes, for those wanting more. Davies and Virgo for case commentary, Hayton and Mitchell for a slightly different structure, McBride for a thematic view, good for essays, apparently.
Supplementary stuff, though. Optional extras.
Exactly. Good if you need them, but focus on the core text and statute book first.
Okay, makes sense. Let's talk assessment. How does this all get tested?
It culminates in a timed, unseen examination, standard format for law, really.
Okay, how many questions?
You get 8 questions on the paper, and you have to choose and answer 4.
Any compulsory ones?
No, you pick any 4 from the 8, so you have some choice, which is good.
What kind of questions? Essays?
Yeah,
Problems?
a mix, typically. Some essays asking you to discuss principles, debates, that sort of thing, and some problem questions where you apply the law to a made-up scenario.
Like advising a client in a tricky situation.
Exactly. But they warn you, don't expect a perfect 50-50 split, and don't assume every single topic will definitely come up.
So no question spotting.
Definitely not advised. They could ask anything from the syllabus covered in the 8 questions. A broad understanding is the safest bet.
How can you prepare for the style of question?
Past papers. They strongly recommend using past exam papers and the examiner's reports.
Why the reports?
They give you huge insights, what the examiners were looking for, common mistakes students made, how strong answers were structured, invaluable stuff.
Right. And just to confirm, the statute book in the exam.
Yes, absolutely crucial. You are permitted access to Blackstone statutes on property law during the exam.
So you really, really need to know your way around it.
You really do. It underscores how central the legislation is.
Okay. Let's try and pull all this together. What are the key takeaways for someone studying this module based on these University of London materials? Actionable advice.
Right. Number 1, I'd say prioritize getting the core concepts and principles straight first. Build that strong foundation.
Don't get bogged down in detail too early.
Exactly. Second, really engage with the module content on the VLE. That's your main guide. Follow its structure.
Makes sense.
Third, choose your core textbook, Penner or Virgo, wisely. Pick the one that clicks for you and stick with it.
And fourth, that statute book again.
Yes. Get very familiar with Blackstone's, know what's in there and where to find the relevant sections for different topics.
Yeah.
It's critical for study and the exam.
Fifth, practice makes perfect.
Pretty much. Use those sample questions, actively apply what you're learning, test yourself. It really helps solidify understanding and builds those problem-solving skills.
Okay. Anything else?
Maybe consider the further reading, but only after you've mastered the basics if you want to go deeper or get different perspectives.
And finally,
Use those past papers and examiner reports. Seriously, they tell you so much about what's expected in the assessment. Learn from previous years.
great summary. This has been, well, a really useful deep dive into the University of London's Equity and Trusts module. Hopefully this gives everyone listening a clearer path forward.
Yeah, I hope so too. It's a challenging but fascinating area. The key really is that solid foundation, working through the materials systematically, and practicing applying it all.
Absolutely. And just to leave you with something to think about as you study, considering equity's historical roots and fairness, and how trusts are used today in so many ways, what do you think you'll find most challenging about this area? And maybe what part do you think will be the most fascinating, the most intellectually stimulating for you personally?
Good question to ponder.
And remember, just one last time, these materials we've discussed are provided by the University of London for educational purposes to support student learning.
Until our next deep dive, keep exploring and keep learning.